On the morning of March 19, 2024, agents of the Bureau of Alcohol, Tobacco, Firearms, and Explosive Task Force executed a search warrant at the home of Bryan Malinowski. Less than 5 minutes later, he was shot in the head. Now, over a year later, his wife has just filed a wrongful death lawsuit against the United States and against the agents involved in the raid. Hey, I'm America's attorney. I've been a lawyer for over 20 years. I've helped over 1.2 million people. And today, we're going to break down this massive lawsuit and find out why Maria Malinowski is claiming the fatal raid was illegal, excessive, and entirely preventable. Now, this story is actually closer to home for me than most events that I cover here on the channel, since the events transpired right here in Little Rock, Arkansas, where America's attorney, me, is located. Ignore Mount Rushmore in the background. Or maybe don't. I mean, maybe we have a smaller replica here in our town. Bryan Malinowski was a respected figure here in Little Rock, serving as the executive director of the Bill and Hillary Clinton National Airport. Now, I know you've heard of the Clintons, but maybe you haven't heard of their airport. For some context, it's the only airport within 2 hours, and it's definitely the air travel hub of the state. Before his death, Malinowski was known for his professionalism, and he had no criminal record. According to the lawsuit, outside of work, Bryan was a passionate collector, starting with coins in childhood and later developing a deep interest in firearms after inheriting his father's gun collection. He often attended weekend gun shows where he bought, sold, and traded firearms and coins as a hobbyist. According to those who knew him, Bryan saw himself as a private collector of guns, not a dealer, and never imagined that his lawful interest in firearms would put him in the crosshairs of a federal investigation. The pun was intended. At the time of Bryan Malinowski's death, federal law required individuals to obtain a federal firearms license, or FFL, only if they were engaged in the business of selling firearms with the principal objective of livelihood and profit. Bryan, a high-earning airport executive, believed his weekend sales at gun shows were part of a personal hobby and didn't meet that threshold. However, conveniently less than a month after the fatal raid, the ATF announced a significant rule change aimed at closing what's commonly known as the gun show loophole. The new regulation removed the livelihood requirement and instead broadened the definition of who is required to get an FFL to include anyone who sells firearms for profit, regardless of intent. As we get into the facts of what happened on the morning of the raid, the details of the regulations are less relevant, but it is important to understand that Bryan would have been reasonable in believing that he was not engaged in a criminal enterprise. So, what exactly happened on the morning of the raid? Well, it depends on who you ask. As the lawsuit tells the story, 10 vehicles carrying ATF agents and task force officers assembled outside the home of Bryan Malinowski to execute a federal search warrant. At approximately 6:02 a.m., agents approached the front porch, taped over the home's video doorbell, and began knocking and shouting. With no response, the team breached the front doors using a battering ram. Bryan, who had been asleep with his wife, awoke to the sound of banging and believed intruders were breaking in. Actually, they were. He was right. He retrieved his handgun and entered the hallway. Moments after the door was forced open, a brief exchange of gunfire took place. Bryan's wife witnessed as he was shot in the head by an agent and collapsed to the floor. The agents did not announce their identity before entering, and the couple had no idea they were facing law enforcement until after the shots were fired. Sadly, Bryan died in the hospital 2 days later. The lawsuit argues that Bryan was operating within the bounds of the law as it existed at the time, and that the ATF's aggressive enforcement actions were based on a legal standard that didn't yet exist, effectively punishing him for rules that were still weeks away from taking effect. Maria Malinowski's lawsuit centers on a series of constitutional and statutory violations that Maria alleges were committed by the ATF and its agents during the pre-dawn raid that resulted in her husband's death. At the heart of the complaint is a Fourth Amendment claim that agents conducted an unreasonable search and seizure by using excessive force and failing to comply with the long-established knock-and-announce rule. According to the suit, agents taped over the home's video doorbell, knocked and shouted for less than 20 seconds, and then breached the front door without giving the sleeping residents a reasonable chance to respond. The Malinowskis were well off. They did not live in some one-bedroom house, and 20 seconds to get from the master bedroom to the front door, if you've been asleep, is not very long. Under the Federal Tort Claims Act, or the FTCA, the United States can be sued for negligence and wrongful death and failure to follow proper procedures. The complaint claims that had the agents acted as a reasonable private party would have acted under Arkansas law, Bryan Malinowski would still be alive. The FTCA claims hinge on whether the government employees breached a duty of care that would be recognized under state tort law, specifically the duty to execute a search warrant without unnecessary violence or risk to civilians. Separately, the lawsuit brings Bivens claims against the individual agents, which is a rarely used but powerful remedy for violations of constitutional rights by the federal officials themselves. The Bivens claims allege that the individual agents personally violated Bryan Malinowski's Fourth Amendment rights by planning and executing a dynamic entry without justification, misrepresenting the danger that he posed, and engaging in conduct so reckless that it amounted to a deprivation of life without due process. The lawsuit emphasizes that the agents had months of surveillance data showing Bryan had no other criminal history, even if his gun ownership was criminal. He posed no threat, and he followed a predictable routine, yet they still chose a high-risk tactical approach more appropriate for violent suspects. Together, the claims portray a government overreach that turned a regulatory investigation, again, based on a suspected failure to obtain a $200 firearms license, into a deadly use of force without sufficient justification or legal compliance. Now, the lawsuit didn't mention this fact, but it is undisputed that because they knew they were going to execute the warrant, they could have surveilled the home for hours in advance and known conclusively that there were no other people or criminals in the home and no potential threats. And to follow on that, I would also add that they were not going in to seize like 3 ounces of fentanyl that could be flushed down a toilet or some other contraband that could be easily disposed of. No, in fact, according to the terms of their own search warrant affidavit, they knew the home was filled with guns, which are dangerous. Arguably, a reasonable task force would go in with even less shock and surprise under those facts, not more. The family seeks not only monetary damages, but also accountability for what they argue was preventable and an unconstitutional killing. Accountability because, despite the high-risk nature of the operation, none of the ATF agents or local officers involved in the raid wore or activated body cameras, which was a direct violation of federal policy implemented years earlier requiring body-worn cameras during the execution of search warrants. The agents also failed to use any vehicle-mounted cameras to record the entry, even though local police had the equipment to do so. What's more, the ATF team deliberately obscured the Malinowski's video doorbell camera with tape before knocking, effectively erasing the only potential visual record of the moments leading up to the shooting. Now, as between criminals and the police, you should ask yourself, who's more likely to block the camera on your doorbell if they're trying to break in? It's not the police. The lawsuit argues that this lack of video documentation represents a serious breach of transparency and protocol, especially for an operation that resulted in a fatality. Without full video evidence, the family claims that there's really no way to independently verify the agent's actions or whether procedures were properly followed, highlighting a broader issue of federal accountability in these use of force incidents. Now, after watching her husband collapse from a gunshot wound to the head, Maria Malinowski's nightmare continued. She was immediately detained by officers, barefoot and wearing only a tank top and boxers, and placed in the back of a cold patrol car for hours. Despite the freezing temperatures that morning, she wasn't given a blanket until nearly an hour later and was denied basic necessities like clothing, medicine, and access to a bathroom. Her repeated requests to go with her husband to the hospital were ignored. Even after it was clear that she posed no threat, Maria was held in custody, distraught and crying, while officers dismissed her pleas. At one point, she was escorted to a fire station to use the restroom, but she was forced to do so under supervision with an officer's body camera audio capturing the sound. I think we have that. For over 3 hours, she remained isolated, traumatized, and without information about her husband's condition. The lawsuit describes this treatment not only as inhumane, but as further evidence of the ATF's disregard for the rights and dignity of those caught in the raid. What comes next in the Malinowski case is likely a lengthy legal battle in federal court. The government may file motions to dismiss some or all of the claims, particularly the Bivens claims against the individual agents, which courts are increasingly reluctant to allow. If the case survives early procedural challenges, it could move into discovery, where both sides would exchange evidence, including internal ATF communications and surveillance records. The outcome could hinge on whether a judge finds the agent's actions were objectively reasonable or an unconstitutional overreach. I'd be very surprised if this case were dismissed on summary judgment, because such dismissals rarely occur when the facts are in dispute, and facts will be in dispute in this case. Namely, who did what and why and when. Because there is actually even a legal argument that even if the victim of the police violence, Malinowski, was brandishing a weapon, or potentially even if he shot first, the entire situation might have been caused by the Gestapo-like tactics of the pre-dawn SWAT team. This situation is a mess. What are your thoughts on the raid that ended Bryan Malinowski's life? Do you support Maria Malinowski's lawsuit? Drop your pro se opinion down below in the comments and let me know what you think. And don't forget to lawyer up with America's Attorney by hitting that subscribe button, or I might just show up at your house in the pre-dawn light and press that button for you. Hey, I'll be back soon with more legal breakdowns, and I'll see you guys then. Actually transpired, without unnecessarily. Regardless, this case is poised to draw a national attention. Whoops.